Good morning. Thank you so much for joining us today. My name is Haochen. I teach intellectual property and technology law at the University of Hong Kong Faculty of Law. On behalf of our faculty, I wish to extend a very warm welcome. We are incredibly honored and privileged that our Vice President, Professor Max Chen, are here to give welcome remarks. Professor Shen is the Vice President and the Pro-Vice-Chancellor in charge of research matters at our university. He is an internationally renowned scholar in the field of logistics and supply chain management. Under his leadership, HKU has been advancing to new highs in terms of research performance. Please join me in welcoming Professor Shen to give welcome remarks.
Good morning, everybody. I got the invitation a few days ago and look at my calendar. It's all booked with other meetings, but I still have to come because this is really one of the most important research directions of Hong Kong U. So I want to welcome you all to this really meaningful and important conference. So as Professor Shen just mentioned, in Hong Kong U, actually, we pay much attention to the new research directions of AI. In fact, before I came to Hong Kong U, I started this Institute of Data Science with the hope of growing everybody on campus doing research in artificial intelligence, machine learning, data science, social science, law, arts, everybody to form a strong group at Hong Kong U so we can actually be leading in the world doing AI-related research. So I'm talking about outreach to all important areas. And law actually is probably the area that first came to my mind because I myself do AI research on logistics and supply chain. But actually in one of the applications, you probably are all using it, is that whenever now you go anywhere, you don't decide where to go. A navigation system tells you where to go. That's an AI system. Sometimes guide you to a wrong direction, a wrong place. Some people get guided to the ocean sometimes. So how do you lawsuit? How do you do lawsuit? How do you sue the AI or the company? That's a question that puzzles me for a long time. And then many of us get hooked on platforms like TikTok and other things. I don't even know the names, but I do know. I read somewhere that on average, an adult in China spend probably 2 hours every day on the social media platforms, right? So is this good or bad? We don't know. But what if you spend so much time, your neck have a problem, you read something that misguided you to something? Do you file a lawsuit about what, right? So there are a lot of things that make me wonder, we cannot just blindly do AI research. We have to figure out the law-related issues, the regulation-related issues for us to be safely innovate and benefit from the AI-related research. So this is why we have this conference. We have our commissioner here. We have top professors from US. We have our leading industry leaders, policy makers, everybody is here. That's why we can be together to brainstorm and figure out some kind of answers to the question that I have. I actually have a long list of questions. Maybe later I can share with you. But there are a lot of important issues. And privacy, I think this is really even more important. Sometimes, right now, if you go on the internet, they always ask you, do you allow cookies? Do you allow this and that? That's very polite of them. Sometimes they just take the data from you. They don't even ask you, right? So that's really bad. Intentionally, take your personal data. Sometimes it's unintentionally. You have a surveillance camera. You have something that just record everything. Is this good to us or is it bad for us, right? So all these things, I don't have a good answer to this. I'm hoping that all of you can brainstorm and then come up with a good idea. I do hope that, I see a full room of smart people. Maybe we can continue this conference in the future, and then eventually be the academic leader and industry leader in this dimension. And I also have some good news to report. In fact, in Hong Kong U, we do have some loyal donors who are really interested in AI. They give already, but I have a donor who is willing to give to AI research in social science and law and arts. So I think this is getting attention to the community, and I hope with my team in the present office and in the Data Science Institute, we can all together do something really exciting. So I wish the very success of this conference. I do hope I can have the opportunity to interact with many of you. I see many familiar faces. And as I mentioned before, I do hope Hong Kong U can be the leader in research in AI, not only in methodology, but also in the application area, especially in law. And this personal data protection is one of the most important areas. So thank you so much for coming today. I do hope we can have interactive interaction, discussion, and friendship come out of this conference. Thank you.
Thank you very much, Professor Shen. I absolutely agree with you that there are so many uncertainties surrounding AI research and development. I think that's absolutely one of the purpose of this conference. We are here to explore a range of, legal issues that haven't been settled yet. With your encouragement, we are absolutely more confident to explore those cutting-edge legal issues. Thank you so much. We are also very fortunate to have Ms. Ada Chung give welcome remarks. As you know, she is the Privacy Commissioner for Personal Data, safeguarding data security in this city. Thank you, Ada. Before her appointment as the Privacy Commissioner, Ada was the Registrar of Companies, Registrar of Moneylenders, and she has held various posts in the development of justice, including the Deputy Law Officer. Please join me in welcoming Ms. Ada Chung to give welcome remarks.
Professor Shen, Professor Fu, Professor Sun, distinguished speakers, ladies and gentlemen, good morning. It gives me great pleasure to address you at this conference on enhancing personal data protection in the age of artificial intelligence. First, I would like to thank the program on artificial intelligence and the law of the Faculty of Law for organizing this conference. As we usher in the new year, the need to examine the complexity of AI from a data protection standpoint has become more important than ever. And it's gratifying to see an impressive lineup of esteemed speakers from academia, businesses, AI developers, AI users, and regulators gathering together to discuss and deliberate on personal data protection amid the unprecedented development of AI. I would say last year, 2023, has unfolded as a testament to the groundbreaking development of AI. Terms like AI, ChatGPT, hallucinate were chosen as the words of the year. Indeed, the last year has demonstrated AI's rapid evolution and also its extensive reach. For example, ChatGPT reached 100 million monthly active users just 2 months after its launch in November 2022. On its first anniversary, it was reported that over 2 billion developers had used the platform, including more than 92% of Fortune 500 companies. Undoubtedly, AI has accelerated its entry into our lives, from chatbots to sophisticated data analytics, and from personalized advertising to credit analysis. However, I must say, challenges abound. Over collection of data, non-consensual use, and accidental exposure of sensitive information are just a few examples of the kinds of privacy risks which AI poses. In a global survey, about 88% of the respondents said that they would be concerned if their data were shared with others in generative AI applications. You may recall that in March last year, thousands of AI experts, academics, and business leaders did call for a pause in AI development for at least 6 months, which they call the summer vacation, out of concerns about the risks involved. Of course, this did not happen in the end, and everyone knows that AI continued to develop rapidly. As the use of AI goes beyond borders, the risk inherent in such use has become a global issue. And I would say this global issue calls for a global solution. And in this context, the Beltley Declaration, the G7 leaders' statement on the Hiroshima AI process, and the global AI governance initiative promulgated by the mainland are just the starting points. This conference, I believe, was held in the same spirit, during which experts from different parts of the world were engaging in intensive discussions on the current state of play and also on the way forward. I note that the conference will feature a broad spectrum of discussions today and tomorrow. The discussions will span across different jurisdictions, from Asia to Europe and to America. Speakers will dive into the intersection of AI and data protection from the perspectives of various industries, including healthcare, finance, and gaming. The topics covered will also be extensive, ranging from the steps that technology companies have taken in building responsible AI to the ethics and security considerations concerning AI. I'm honored and I look forward to joining a panel this morning, which will address the risks of AI from the regulatory perspective, featuring privacy commissioners, ex-privacy commissioners, senior officers, and privacy professionals from different jurisdictions. Last but not least, with great advancements come great responsibilities. While we all enjoy the benefits of AI, I firmly believe that the responsibility to manage its risk lies with each and every one of us, including regulators, developers, industry players, and even end users or consumers. It is more important than ever for all of us to join hands to collectively address the challenges brought by AI so that we can create a win-win situation where the potential of AI can be maximized while safeguarding the interests of individuals and society as a whole. To this end, we need to foster an open dialogue to advance data protection in the era of AI. I encourage you all to join the discussions today and tomorrow, and I wish you all a very fruitful and inspiring conference. Thank you.
Thank you so much, Ada. Indeed, there is so much to explore and discuss today. So without further ado, let's move on to the keynote speech panel. May I invite Professor Christopher Yu and Professor Anupam Chander to the podium. Our first keynote speaker is Professor Christopher Yu. Professor Yu is John H. Chestnut Professor of Law, Communication, and Computer and Information Science at the University of Pennsylvania. He is one of the world's leading authorities on law and technology. With his groundbreaking research and original contributions, Professor Yu has made a significant impact on the areas of internet law, intellectual property, telecommunications policy, and innovation. His work has provided extremely valuable insights and guidance for policymakers, scholars, practitioners in these areas around the world. It is with great pleasure that we have him today deliver the first keynote speech that promises to enlighten and inspire us all. In the keynote, I believe he will lead us to challenge the conventional wisdom of personal data protection.
Well, thank you very much, Professor Sun. You're making me blush. It's a great honor to be here. It is a privilege to return to Hong Kong U. I've not been here since before COVID, and so it's always a pleasure to come back and to see the university doing so well. And I can't imagine a more important occasion to come or a more important topic to address than AI. I often say a joke they always say that Americans always are supposed to start remarks with a joke. And maybe it's not a joke, but I've never seen anything that caused the entire academy to lose its mind at one time, like ChatGPT. I mean, it's just gone off like a bomb. People have gone crazy. And what's fascinating to me is the number of people who are extremely cautious about it, many of whom know nothing about it. And there are many ways to make policy. Ignorance is not my preferred mode. And so the question is, how do we move forward? I celebrate the ambition that Hong Kong U has to become a leader and to do the kind of interdisciplinary work and to bring things together, because it's transcending traditional boundaries in ways I think are very important. And so and deliberately in my remarks today, I'm going to throw out some ideas based on some other work I'm doing. And if anything, I always think to start a conference like this, the first speaker has some obligation to be slightly provocative. And so with any chance, we'll have some discussion, and I will stimulate at least some reactions, which will set a tone for intellectual engagement for the entire day. So what's striking to me is a great deal of the discourse today in data protection is framed really centered on the consumer. The rights are largely defined in terms of their ability to control the uses of their data, be aware of it, but it's very, very consumer-centric. And there are derogations from it for the public interest, but again, they are considered exceptions. And we start with this idea of framing of consumer rights. And if you see, even in the US, where you see certain Supreme Court decisions, such as the Sorrell versus United States decision, to the extent to which they'll take into account other rights, they will often take into account not just the data subject, but the data holder. But and that has become an important thread in US jurisprudence on data protection. I think that perspective is too limited. I do think that there is a societal dimension that is missing. We've learned that all legal interventions have collateral impacts. They have secondary impacts that have to be understood. And that, in fact, if you look at the way most data protection law is structured, it's not done so in a way that really takes those into account directly. Maybe you can stretch some other doctrines to find some indirect coverage for them, but I actually think there's a missing piece here. And I hope that the examples, the two main motivating examples I give, will give you a sense of what I have in mind. The first primary motivating example focuses on the right, what in EU in the GDPR is now called the right to erasure, but is more commonly known as the right to be forgotten. And I'm really looking at it through the lens of the work of George Akerlof, for the Nobel Prize-winning economist, who wrote a famous article in 1970 about the market for lemons and the notion of what we call adverse selection, about how the conversion of certain information to hidden information in data markets can have adverse effects. all of us also should all scholars here should take tremendous inspiration and comfort from George Akerlof as well, because when he submitted that paper initially, he was told that it was obvious and wrong. How those things can both be true, I'm not entirely sure, but he was told it was such a useless idea, he should abandon the project altogether. And fortunately for his career and for all of us, he didn't. So the answer is the reviewers of journals don't always have the best judgment. So that's what I always tell myself when I go through the revise and resubmit process. The second thing is an addition, which is I think that law schools have a bias, which is we teach primarily through a litigation model, through cases and through enforcement actions, looking ex post. And in fact, one of my constant criticisms of one of my deans when I was teaching at Vanderbilt, he said it's not just a litigation model, it's an appellate litigation model, which is a very artificial way to think about things. But when law actually comes into practice for most people, it's not through dispute resolution. In fact, law, for the most part, exists to give clear rules for us to arrange our affairs in a manner that avoids dispute resolution. So in fact, the business part of law is not actually what we often talk about in class. It's often how people react in terms of rules. And in fact, it's a compliance system. And one of the privileges I have at the University of Pennsylvania is I teach with the chief privacy officer of the University of Pennsylvania. And she brings a very different sensibility as someone who's attempting to actually comply with the varying obligations. And she's actually taught me a great deal and changed the way I think about a lot of these things. And I'd like to share some of those perspectives with you as well. And my overall goal is to convince you, or at least put on the table, that there are societal considerations that are not adequately taken into account, motivated by these two primary examples, which I'll talk about now. So the right to be forgotten, as you know, gives data subjects the right to tell a data holder to require them to remove certain information. It originally began in a European Court of Justice case under the 1995 Data Protection Directive that wasn't quite as extensive as requiring people to erase data. It was more de-indexing from search engines. But now under the General Data Protection Regulation by the EU, or GDPR, it is clearly a right to erasure. This is not just a European phenomenon. The right to erasure, or the right to be forgotten, has been incorporated into a new movement in the United States where we have no national or federal privacy law. So individual states are enacting privacy laws. As of now, it's constantly changing. This may be dated. Last count was 13 out of the 50 states. I haven't paid attention in the last month, but every single one of them has included a right to be forgotten within its provisions. And what's interesting to me is what is the effect of the right to be forgotten? Is you're taking information that used to be visible to the entire world and part of the public record in a database, and giving the data subject the right to have that removed from that information. And to use the language of Akerlof, it takes what would otherwise be public information and turns it into hidden information. And Akerlof, in his theory of adverse selection, said, hidden information can have a very deleterious effect on markets. And he used as his primary motivating example, although he used many examples, the one in the title is about used cars. Okay. And in used cars, I don't know if you have the same phrase for this in Hong Kong. Some cars are very poor quality. We call them lemons. And so he talked about the market for lemons. So his point is, if you have a good of uncertain quality, and used cars, as you know, maybe someone's driven it very hard, maybe it was manufactured poorly, and it's actually a below value car. That's one kind. And you see other cars that are above value cars. And the presumption here is the value of the car is very well known to the owner of the used car, but is relatively difficult for other people to determine. You could take it to a mechanic, it's costly, it takes time, and it actually becomes a drag on the market. So the point he would make is, first, if you have a market for a good of uncertain quality, how do you price it? And the natural assumption would be you price it based on the average value of the car, of the average value of a typical used car. Well, this creates a problem, which is for people who own a car that is above average value, they look at the price that they would get and they decide, this is a terrible deal. It says this should be costing $5,000. I have a car that's worth more than $5,000. I'm not selling. So by definition, what you should see in this market is a market that consists entirely of cars that are worth less than $5,000. And so this is essentially becomes a form of like Gresham's law, where bad money drives out good, where you have these people with above value cars exiting the market and not selling. And this would happen, in fact, even if you took like a winner's curse discount on the average price and say, okay, we know that there's some flaws here, we'll lower that. You're still going to have a level of a standard price where there's people of above average cars, and they're going to exit. And this is all because the true value of the car is hidden information that only the owner knows, and is hidden from the rest of us. And in the classic literature, which is reviewed largely in a piece that I've got online that hopefully I'll place in the next publication cycle, is this can cause markets to contract, because as sellers withdraw from the market becomes smaller from its optimal level, even though there would be willing purchasers and buyers. It actually causes some buyers to exit the market because of the uncertainty. And in the limit, it can actually cause the market to collapse altogether. And this comes out very strongly in the insurance industry. You see this. And what I find is fascinating is, even though this is a fairly technical but fairly easy to grasp economic concept, it's been actually recognized in at least half a dozen Supreme Court cases in the United States, most recently in King versus Burwell, which dealt with what we call the Obamacare statute, which provide expanded medical care, government provided medical care in the US, basically focusing on, if you didn't buy insurance, you had to pay $500 into the fund on the principle that if you know you're a healthy person and a better than average risk, you have the incentive to exit the market, in which case you have an insurance market that consists entirely of below average risks. And so what you see is you have this ability, when you can't tell, for the market not to be the same, to be contracting below what the optimal levels are. So the interesting thing to me is, you put this in the AI and the right to be forgotten, you start to understand how a similar dynamic can occur. So AI depends on training data. And in fact, they're trying to do predictive analytics. What my friend I saw once written in an article, I wish I could remember it so I could give justice to the person. They call AI stochastic parroting. You're repeating back what you've seen in the data with a certain amount of uncertainty, because it's a probabilistic function about what the next representation is going to be. But it depends on the accurate representation of the information in the data itself. Now, here's a problem. If people have the ability to withdraw information from the pool of training data available to AI, AI will now be trained on a skewed set of data that's not necessarily reflective of what is actually the reality that you're trying to mimic. And if you assume that who is going to exercise this right to be forgotten, these are going to tend to be the people who have adverse information, which would lead to bad decisions on their part in the data set. So if it's about, say, financial data to get a loan, people who have good credit have no incentive to withdraw their information. In fact, they want that information there. People with bad credit have higher incentives to do this. And so you'd expect there to be a systematic bias for it to misrepresent the quality of the data in a way to overstate its quality, in ways that can be quite destructive. Now, this is a wonderful theory. There's a very nice paper by Liad Wagman, co-authored by Liad Wagman, and Liad Wagman is an economist who also was the advisor to the Federal Trade Commission recently. And he studied a phenomenon in the San Francisco Bay Area, where different cities around San Francisco are changing their privacy rules for financial data from opt-out to opt-in. And we all know that defaults are sticky, and by shifting from opt-out to opt-in, you're going to see a lot less information available. The empirical test is a little bit more elaborate than this, but it can be summed up this way. The result of this phenomenon in the San Francisco Bay Area was mortgage prices went up. Why? With the lack of data to be able to identify and determine good risks from bad risks, the lenders had no choice but to include a risk premium on all customers to reflect their inability to determine the risk. And so, in a sense, the data subject who exercises a right to be forgotten in this case is protecting themselves. What they're not taking into account is the change in the quality of the data pool will have a systemic effect on all purchasers of mortgages, whether they exercise the right or not. And this is an inevitable element, a dynamic that I don't really see adequately taken into account in the data protection law, that there is an externality or an effect on overall markets. We all know that the lessons from economics is that an illegal intervention is rarely the last move. There are moves and counter moves and secondary impacts that have to be taken into account. And a lot of the way law is designed right now doesn't really have a great hook for doing it. There are some, I'll talk about them in a minute, but they're not that well, that's not really the focus of them, and the language around them doesn't seem well designed to taking care of that. Now, the example I give you in San Francisco Bay, it applies to everybody, although you can see if someone was going to opt out versus opt in, if you're highly motivated, there is a certain individual exercise you can do. The right to be forgotten is not done across the board or broad brush, it's done individually, which allows people to act opportunistically to hide information based on what their benefits and costs are. And one of the most striking things to me, I don't know of a great empirical study of this, but I do know that on the rare disclosures of who is exercising the rights to be forgotten, it's actually being exercised by a new group of actors called reputation management companies. We often tell our students before they go on the employment market, look at your social media presence and make sure you don't have any embarrassing pictures or stories of you up there. You should scrub your presence. There are companies that'll do that for you for the social media for students, for employment. What we're seeing now from reputation management, there's new companies that are doing it for using the right to be forgotten to actually clean up your digital footprint to make you look better than you actually are and to take out the adverse information. And so what you can start to see is a commercialization of this in a way that's going to represent people who are well enough funded and sophisticated enough to exercise it in ways that are going to introduce systematic biases into the data pool. And the question is there a mechanism that we should take this into account? Well, the reality is to me is your exercising your data protection rights are important for you and yourself, but the missing element is there is a societal impact that we need to find a way to take into account to make sure that we actually look at the benefits and see how they go. My other example is on compliance costs. So one of the interests, as I mentioned, compliance is how law affects most people. And what I learned from my co-instructor is that compliance costs is the world of compliance is if you don't write it down, it didn't happen. You have to have documentation for everything, for verifying everything. And so what does that mean? You have to create systems for documenting all of your exercises of rights, all your compliance with all the requirements you're under. You have to train your people to do this. You have to do ongoing auditing to make sure they're actually doing it and the like. And on an ongoing basis, there is a non-zero cost that can actually be quite significant. I know, for example, in the antitrust settlements for most in the data protection space, actually the privacy settlements by the Federal Trade Commission, one of the requirements is these ongoing auditing and reporting requirements. And I know from my friends in the companies, they actually find that the auditing requirements are more burdensome than any changes imposed to their business model based on the other injunctive aspects. It's extremely costly and time consuming. Now, there is a tendency to equate certain rights with just to assume that they're beneficial. So in the US, the starting point for teaching privacy is 14 what were called Fair Information Privacy Principles developed by Health Education Welfare in 1973 that have largely been enshrined in the healthcare statute, which we call HIPAA, the Health Insurance Portability and Accountability Act. And what's interesting is it has many, many rights, but one of the rights you have under HIPAA is you can ask any hospital system, say the Penn Hospital System, who have you given my data to? Now, I would wager that if you did a poll and you asked people, should you have that right? Well over 90% would say yes. One of the more interesting things I found out from just talking to people in the industry is this right is asserted vanishingly small, rarely. Something on the order of less than once a year for the typical institution. So we have a world here in which you have a regime that's creating enormous compliance cost, but does not create any meaningful protection for consumers. Now, it's a tendency, we look at the 14 Fair Information Privacy Principles, and that has become the yardstick against which we measure whether a privacy regime is good. But no one's actually ever validated. It can't be that all 14 are equally important. And that, in fact, we should be thinking about them as a relative importance scale or looking at different dimensions. And we should be thinking about, at some point, maybe we draw a line across the 14 and say, you know what, at some point, the game is no longer worth the candle. Now, maybe the answer to all 14 are important, but this analysis of thinking, what are we actually gaining versus what are we actually paying in terms of cost is a sensibility that we generally lack when we discuss these types of rules under FIPS. There's another example I'll give you, which is the President's Civil Liberties. So we have a statute about national security called the Foreign Intelligence Surveillance Act, or otherwise known as FISA. And among the many things about it is FISA is entirely confidential and it has a lot of restrictions on it. So we don't actually know a lot about what happens under FISA. And it's interesting, in the world of conventional data protection, rights are often used as trumps, where you're saying if this right's being invaded, that's the end of the argument. In national security, it goes the other way, which is if you assert national security, everything else gets out of the way. But they actually have an organization called the President's Civil Liberties Oversight Board, who get the necessary security clearances. And they actually examine the performance of FISA when it's up for renewal. And in one of their most recent reports, they looked at two provisions. They said they both invade privacy, so we were concerned, but one is actually solving national security problems. And on balance, we think we should keep this one. But another one is not doing anything useful in terms of protecting national security. All it's doing is invading privacy. We should get rid of it. This is another version of that sort of cost-benefit analysis, which is we need to think about what's actually effective in achieving the goals we're thinking about. And in fact, trying to understand how that's playing out. And in addition, the last point I make up here is there are empirical studies that bear in mind that there is a burden on small and medium-sized enterprises from compliance costs. That is pretty clear. GDPR is having a negative impact on small and medium enterprises. And the large companies, they're also affected, but they can afford to pay. So what I'm thinking is that, in fact, there's a tendency to say, if you look at remedies that protect data, personal data, it's very tempting to say we should do all of these. Of course, don't you care about data? I actually think there has to be a sensibility. It's like it can't be that every single remedy we can think up to protect personal data is necessarily going to be justified. And we have to have some means of thinking about when they're justified and when they're not to actually create a meter. Why is this important? In AI, this is going to prove critical. And so if you think under GDPR, you have to have a legal basis for processing data. And you have to have, if you're relying on consent, individualized consent for every different form of processing. So all the Reddit data that trained ChatGPT-2 probably did not get that consent because no one was planning to do AI training on this. In addition, if you get consent, you have to give the right to withdraw consent. There's an interesting question of then, if someone withdraws consent, you have to scrub the algorithm to withdraw the impact of it. And there is a science that people are trying to develop this. But in addition, you have to provide a wide range of rights to every person who has, every European data subject who has personal information in the data set. And in things like Reddit and Wikipedia, it's extremely likely. So, we're just access, just as examples, there are others: rectification, erasure, restriction of processing data, data portability, right to object to automatic processing, elevated for sensitive data. I could go on and on. And the point is that a lot of the AI community is saying imposing this level of restrictions on AI training data eliminates these sources of data as basis for training data, and you need large amounts. You need large corpus to train this. We saw Italy step in. They have blocked ChatGPT for a while. Interestingly, I don't understand why they ever released it. I don't see how it complies. And they have ongoing threats about saying that they made some progress, but we're still going to be watching. I know there's more to be told, but this is a very big issue sitting out there. And the interesting question for me is, in assigning these rights and understanding them and thinking about de-identification and the uses, how should we be thinking about all of them? Is there a way we should be thinking about the potential benefits of allowing certain uses versus the threats they pose, and internalize that into data protection law that would be beneficial? So the other thing that's interesting, as opposed to a rights-based approach, here what we see is, in fact, under the laws, you have social exigency requirements, and these came out quite vividly in COVID. It's very clear with, say, quarantines, where we've taken different people's individual rights, but for the sake of public health, we've overridden them. We've seen widespread data sharing during COVID, that the US enforcement officials basically said, we're going to look the other way because we need to share information to solve this problem, and we did. And what's interesting is we see this notion of allowing this to come in. GDPR has public interest exceptions, but they tend to be in areas, the explicit ones are in areas like public health, research, statistics, and these things and the like. Whether it be done for something as mundane as economic interest, business taking advantages of AI in different ways, I think what I've seen in the secondary law makes me quite skeptical that people would admit, the regulators would be willing to take that step. But what's interesting is any rights-based analysis is often used as a conversation ending thing in the discussions. Oh, if it's violating a rights, that's it. To me, that's actually a very artificially limited vision of rights. All rights under any system should have a notion of proportionality. Now, what's fascinating to me is there's different formulations of proportionality. And in the fourth factor, sometimes it's looking at the burden on the individual. Sometimes it's a burden on competing groups. And it's how you formulate that's critical for what I have in mind, because if it's competing groups, there's room for societal considerations. If it's only the data subject, there's not. So what the alternative would be is a risk-based analysis. And what's interesting to me is it can't be that all uses of AI pose the same risks. And the example, there's a colleague of mine, Carrie Colonese, who specializes in studying how governments are using AI. And one of his favorite examples is the first use of AI by the US federal government was handwriting recognition by the postal system. Now, this is something that's going to reduce the cost of spinning mail. The risks at stake here for mistakes is relatively low. And we see there should be a spectrum of things, of uses that become increasingly problematic, and that we should be thinking about that as part of the calculus and be more permissive under this approach on things that are low risk. Now, what's fascinating to me is the EU AI Act initially proposed, very rudimentarily, a risk-based system that really looked at the use cases and tried to understand them. A lot to be developed because we don't know a lot about how they handle low-risk systems, but that was there. And then ChatGPT happened. And the Spanish presidency was pushing for, actually, instead of looking at the use cases, looking at regulating ChatGPT directly, even though it itself is not a use case, it's an input to another use case that's going to be down the line. It actually engendered an objection from France, Germany, and Italy, saying that violates the risk-based principles of what we're trying to do. You should be able to just pick this up in the use case analysis. But Spain was very persuasive and actually convinced them to include higher restrictions on general purpose AI, which is what they're calling foundation models. And in fact, they're saying things that don't have systemic risk are just transparency requirements, but things with systemic risks have this heightened number of obligations. And they define systemic risk based on the amount of computing power it needed to train the AI. So all of a sudden, we don't have it as a use case, output-based perspective. We're now, again, looking at inputs. And it's one based on that's no longer technologically neutral. And in fact, it engendered a good deal of resistance from them. We'll have to see how this goes out. But I actually think this risk-based approach in terms of looking at outputs instead of inputs is a very interesting dimension that I think needs to be explored. So in conclusion, what's the plea I'm making? I actually think the rights-based approach is really looking at first-order effects. And they're important. But anyone who does law knows that it's rarely an equilibrium when you go in. In fact, every intervention we've seen has often had reactions which we have to anticipate, often frustrating the intent of the intervention to begin with. And without understanding what these might be, we risk making major mistakes and using data protection to hurt AI in important ways. And that, in fact, we need to look at the secondary consequences and take them into account. And to me, I'm actually starting a large AI project to try to turn standards into things that technologists and data scientists and computer scientists can actually turn into meaningful code, which is we're used to living at these very high levels of generality. And we have a specialist named Nicholas Price at the University of Michigan who works on healthcare. And he was once asked, what do you think the biggest risks of AI is in healthcare? And his answer is that in 10 years. And he says his big fear is that we'll use it too little. And we'll miss a great opportunity to actually train this. And you can see with anonymized data, we just need to train, let's say, image recognition to do this. There are ways we can render this safe. And he's worried that if rules about individualized consent get too strong, that we'll lose this. And that, in fact, we need to really look at the fact that it hurts the total amount of data quality has an impact on AI, but also compliance costs has an impact on AI. And that, in fact, the rights discourse should know that all remedies and all risks are not the same, that a little bit more sophistication and graduation, I think, would do a lot in setting a world in which we simultaneously protect people against the dangers of AI, but still promote the uses where it's safer and we can actually make that determination. Thank you very much.
Thank you so much, Professor Yu. Thank you for sharing with us so many thought-provoking thoughts that would enable us to reconceptualize the nature and scope of personal data protection. Our second keynote speaker is Professor Anupam Chander. Professor Chander is Scott K. Ginsburg Professor of Law and Technology at Georgetown University. A renowned scholar and expert in the field of international law and technology, Professor Chander has made a significant impact on the intersection of law, globalization, and technology. His work seeks to ensure that technology helps build a more equitable world. The author of the book, The Electronic Silk Road, he has served on the Executive Council of the American Society of International Law and is a member of the American Law Institute. Please join me in welcoming Professor Chander to deliver the second keynote.
Thank you very much, Professor Sun. I'm so grateful for the opportunity to return to the University of Hong Kong, to return to Hong Kong itself, such a beautiful and dynamic and cosmopolitan city, and to follow after Professor Yu's fantastic opening keynote. So in spring of 2023, here we go. The CEO of OpenAI, Sam Altman, embarked on a world tour. He started a dizzying journey. Here he lists the 17 cities that he was off to, every continent but Antarctica. Sam announced the trip on Twitter, of course, that then Twitter, I think, or X as it now is, and a commentator suggested a name. Sama World Tour. Another commentator followed up with a reply with a mock-up of a commemorative t-shirt. But Altman's tour was not just the travels of a rock star. He had serious business to attend to. He recognized that his company's very existence depends on the goodwill of regulators across the world. These are, if you look back, I don't think we can go back. If you look at this is, of course, capitals across the world, largely that he is going to. After all, his company's main product, ChatGPT, had already, by that time, been banned in Italy, as Professor Yu mentioned. And as Professor Yu rightly noted, even though the Guarantee allowed OpenAI to offer ChatGPT, it's not entirely clear that it is in fact legal under the GDPR as it stands today. And we will see lots of questions around this in the next few years. Of course, it's not just privacy law that keeps Altman up at night. Countries across the world are racing to create special rules for AI. So here's the Guarantee's intervention. And of course, it's not just that it is banned in China. I'm sorry, banned in Italy. We see here the possibility that ChatGPT is not available in China. Here is my effort to reach ChatGPT from my hotel last night. And when you look at the list of supported countries, China, and including Hong Kong here, are notably absent from that list. So are we going to see the rise of a splinter net where global services become impossible? Will we need rules for interoperability across jurisdictions? What would interoperability look like for AI? Are we likely to see a new Brussels effect in AI? Will Europe write the rules for the world? And if so, what does that even mean? So this picture right here suggests that we are already seeing the rise of a splinter net. It's already here. Now, these are questions, the types of questions that privacy law has previously faced. And so what I want to do this morning is try to set out what we can learn from our prior experience with the globalization of privacy law for the globalization of AI law. I want to argue first that this is warranted. that there are similarities between the two spheres. First, both are forms of data regulation, including the collection, processing, and storing of data. Second, the concerns cover the practices of both the public and the private sector. Professor Yu mentioned Carrie Coglianesi's work on the public sector, but many folks have focused especially on the private sector's collection and use of information as in respect to AI. Third, as OpenAI discovered, it was data protection regulators that raised the first legal concerns with AI. And now we see increasingly alongside copyright lawyers. Fourth, we can even understand data protection as the original AI regulation, as much of the focus, at least in Europe, was on automated processing. And I'm going to skip a couple slides here. So this is the GDPR, and as every expert here knows, it focuses on the automated processing of data. That is the condition for the application of the GDPR and the data protection law of Europe generally. Data protection law began in the 1970s as a response to computerization. The fair information practices principles that Professor Yu mentioned were, of course, a response to the development of computer databases, or as they were then called, data banks. Even our term databases is a more modern invention. The worry was that we needed new rules when computers, rather than humans, do something, potentially because of the capacity of computers to process data in ways that humans could never do themselves. Fifth, the need for cross-border rules was evident early on with data privacy. There was a concern that differing data privacy protections would make it impossible to transfer data across borders. So the worry about a splinter net, in some sense, for data was there from the very start. If you look back at this is a concern that I found as early as 1974. This is not new, the questions that we're asking today. The Data Protection Directive both sought to respond to this question. Finally, another similarity, data protection law already covers a significant amount of ground related to AI. The GDPR even has rules for automated decision-making in the GDPR itself. I think I have here a slide demonstrating some of this. So data protection law is already the law of AI, along with a variety of other domains as well. Of course, there are differences as well, and there are limitations. First, there's increased concern about geopolitics with respect to AI. Defense and national security have become especially important, urgent issues with respect to AI, though of course they are very important with respect to data privacy as well. Second, we've seen many people raise concerns about an existential threat to humanity from AI. We didn't see that same level of alarm about the existence of humanity going forward from the rise of computer processing of personal information generally. There is a faster pace of regulation with respect to AI than there was with respect to data privacy. Data privacy developed from 1970 onward in Europe and the United States at a much slower pace. And the technology seems to be advancing even faster than the data privacy technologies advanced over the last few decades. It seems hard to remember that ChatGPT is only a little bit more than a year old in its public version. Okay, so what might we learn? So first, I want to argue that legal fragmentation seems nearly inevitable. The splinter net is here, and it is coming. It will get even more splintered. So we see that first of all, we see this across the world. Europe has taken an early lead in enacting a broad law. China has already issued and actually beaten Europe to the punch with laws in place and guidelines that are in force with respect to, these are just early versions of this over the last couple of years. So already we're seeing various approaches. The US has adopted, the FTC has been very much focused on using its existing powers under statutes that are almost a century old to apply them to AI. And now we see this, these developing across the world. So fragmentation is inevitable because it's not possible to have a single global law regulating AI. There's tremendous variation in what is legal across the world, and therefore in what it is legal for AI to do across the world. Let me give you an example. Take the issue of real-time facial recognition. This will lead to different outcomes by different jurisdictions across the world. There may be certain rules, and even the scope of when it is permissible will vary across the world. Consider even something more standard like discrimination. Countries differ on their rules of discrimination. For example, the United States, compulsory retirement at a particular age is considered illegal, a violation of our anti-discrimination law. While, of course, it is legal in many jurisdictions to have compulsory retirement. Even where rules might appear the same on the surface, such as rules against hate speech or disinformation, regulators will differ on what is hate speech or disinformation. Thus, what ChatGPT can legally say in different countries will differ. So it will have a different response depending on where you ask the question, because the law will require that. Okay. Now, I also want to say that that's just a descriptive exercise, but I want to offer a normative argument as well. It's also important that there be local enforcement that is focused on the local conditions. I want to give you an example. In 2015, Volvo was developing a feature in its cars that it calls large animal detection. Volvos with this feature would automatically identify large animals, thereby avoiding collisions and saving lives. But when it tried this feature on Australian roads, it realized that the AI didn't recognize kangaroos because they jumped, unlike any animal that it had previously seen. Luckily for Australians, Volvo recognized this problem during testing in Australia before it deployed this feature. It began training its algorithms to recognize AIs. I want to point out that collisions with kangaroos are a real problem, okay? A deadly problem even. Here is a picture I took in Australia, and in front, what you see there is what they call a roo catcher, okay, to catch the kangaroo before it hits the main body of the vehicle, okay? So this is a serious issue, and as Professor Yu points out, here is a real benefit from well-trained AI. It can, again, literally save lives, but it has to be properly designed. Okay. And so this is a suggestion that Volvo acted responsibly, but it's not clear that every company applying AI in new environments will be similarly responsible. Today, companies are offering AI tools that help make hiring decisions or approve loan applications or evaluate insurance claims or even help you find a partner, and they're offering these services across the world. Literally, we're coming into a world in which your credit, your job prospects, your insurance claims, the news you read, and even the dates you go on may be determined by faceless computers in a different land. So AI itself has what I describe as a kangaroo problem. It needs to understand local conditions in which to work in order to be accurate. But companies have an incentive to roll out AI as globally as quickly as possible. There are reasons, therefore, to believe that AI systems will make more mistakes as they cross borders. First, as I've pointed out, AI might be designed for different environments, as the kangaroo example demonstrates, nurtured on data from people that might behave differently. Second, because of the desire to claim the first mover advantage, attracting both media and venture capital, companies may roll out AI before it's ready for particular environments. And because machine learning data sets benefit, machine learning systems benefit from large data sets, the opportunity to engage more persons across the globe may also tempt companies to do this. Third, the quality of its judgments will be hard to assess because firms have an incentive to proclaim the effectiveness of their AI, while individual users cannot amass the overall data necessary to evaluate those claims. Thus, again, we need governments to ensure that the AI that is being offered locally is in fact accurate and responsive to local conditions. Okay. Now, I also then want to argue that we are likely to see a Brussels effect in AI. We saw for privacy law, countries adopt data protection, often modeled on European law. But keep in mind why they did so. It was often to enable trade with Europe. So enable trade with countries that already had a data protection law and were therefore reluctant to pass data to foreign jurisdictions which lacked those protections. Now, of course, there are workarounds in European data privacy law to allow for data transfer mechanisms. I also want to point out that this was a key feature of European law itself. That is, sorry, I'll come back to this. Europe's data privacy law had itself the desire to create a single union within Europe. The data privacy law was written in order to facilitate the free movement of data. This is in its very title. Okay, on the free movement of data is part of the European law, is a fundamental part of the European law. And by the way, this is also true with the GDPR. If you look at this, the official title of the European law is, again, includes the free movement of such data. Trade and commerce were built into these rules from the start. They're one of the key motivations for these rules. So will the Brussels effect happen with AI as well? As Anu Bradford describes, the Brussels effect comes in two forms, de jure and de facto. The de jure forms means that a foreign jurisdiction adopts EU law. The de facto form means that a corporation adopts EU law, even when operating outside the EU. So let me return to the question of whether OpenAI and Guarantee. I want to argue that the Brussels effect is already in evidence. So you'll recall that OpenAI responded to the Guarantee, the Italian data protection authority, in spring of 2023. And some of the responses that it made, some of the changes it made, it rolled out globally. Okay, so there again, you see the de facto adoption of EU law for the globe. But some of those, it did not roll out globally. So some changes it made only with respect to Italy and Europe, and others it made with respect to the world. So I think you will see companies picking and choosing what changes they want to make in this way. Now, let's turn to the de jure question. Would countries like Brazil and Nigeria and India adopt European-style law in order to make it easier to trade with Europe? Here, I want to argue that it's not so clear that there is this natural de jure push from European AI law. It seems easier to rely on direct application of EU law to foreign companies than to worry about whether the law of the AI provider's home jurisdiction is equivalent to EU law. That is, AI providers may subject themselves to EU law directly, showing that they comply with EU law. That is the way the AI Act is framed. It applies directly to foreign providers supplying AI services within Europe. It doesn't turn on what the home jurisdiction's law looks like. This reduces pressure for their home jurisdiction to adopt EU-style law. So I suspect that we'll see a lot more of the de facto Brussels effect than a de jure Brussels effect. And again, the de facto Brussels effect kind of with companies picking and choosing which of those aspects of European law they wish to transpose to the rest of the world. So I will let me just move on quickly here. I also want to mention the question of geopolitics. Okay, return to this slide. Recall the image of ChatGPT unavailable in China. Why? OpenAI doesn't tell us. It doesn't tell us why it chooses to be in or out of any particular country. First, there's the possibility that OpenAI is illegal in China. So that's one possibility. Perhaps it doesn't feel that it will satisfy Chinese laws on these issues. Second, there is an equally plausible explanation that it may not be consistent with US law for OpenAI to offer these services in China. So what you're seeing is the development of export controls with respect to AI as well. So you're seeing this as a new complication for such services. It may be that the export controls don't currently cover ChatGPT as it stands today, but as ChatGPT becomes more powerful, they may do so in the future. And so this may be an effort to both avoid the risks that it might face both in China or from the United States. Okay, let me conclude. Just in the interest of time, I want to return to this. In 1962, Volvo received a patent for the three-point seatbelt. So Volvo here is my exemplar of a responsible enterprise operating globally. They then licensed it for free to everyone else, okay? So that everyone could benefit from this technology. Perhaps I think that companies should begin sharing with each other the lessons they have learned and how their AI systems can also fail, so that others can try to protect against similar failures. Now, this kind of information sharing might be very difficult as well. How do you share between companies in different jurisdictions, say across the world, across various legal systems? So I think we should, as regulators, try to encourage this kind of information sharing and collaboration so that we can create more safe global AI. Thanks very much.
Thank you so much, Professor Chander. It's great to know that there's also an animal protection dimension of AI and personal data, because we have heard so much, intersection between AI and humans, right? Thank you. Well, why don't we have a quick discussion? So I want to ask each of you a question and then open the floor for Q&A. So thank you again. So for Professor Yu, I have been thinking about the relationship between personal data protection and intellectual property protection. Because if we follow this rights-based approach, data could be seen as property. Well, in intellectual property, it somehow is a little bit different with the word intellectual. But there is a very special arrangement in IP law, especially in copyright law. We have very strong limitations on exclusive rights conferred upon rights holders, for example, fair use. But at the same time, it's such a delicate system. At the same time, if you can recall, the fourth factor of the fair use actually guards, it is intended to guard, a rights holder, copyright holder's interest, protecting the market value. So I can see that, such a, interesting system imposing strong limitations on rights at the same time, so trying to protect business, the commercial interest that you care about tremendously. So I wonder whether the new, model, for example, risk-based model or, whatever, anything that you can think that, we can learn from the IP regime.
So thank you very much for the question. I'm going to answer it again, perhaps more provocatively than you intended, which is, there's a very good argument that copyright doesn't matter anymore. Back, if you go back, I don't know, 20 years, all the craze was about the cloud. And so I actually edited a volume about the cloud, and I asked David Nimmer, who's the author of the major copyright treatise, to write a chapter. And he pointed out that, in fact, what we're seeing now for the distribution of content, we're no longer doing it as goods, we're doing it as services. We don't buy music anymore. We buy streaming services. We don't buy academics. We don't buy journals anymore. We access them. The copyright restrictions only relate to property. If you have it as a service, first sale, who cares? Duration limitation, who cares? It doesn't matter anymore. It's a service. And the interesting question is AI a product or a service? And particularly one that learns and goes on an ongoing basis and feeds back information. I think there's a pretty good argument you're looking at a service here. And so the notion of IP putting limitations on is a problem. I mean, I don't think it's going to be as the meets and bounds within copyright law isn't the big issue. The stuff about, for example, of memorization and the need has to be solved by deduplicating data sets, problems about trade secrecy, disclosure, in transparency requirements. I think there are some issues of IP that float around out there. But in terms of the core elements, I don't even think you need to get to the fair use claim, because I don't know that you're going to get liability to begin with, because if you do it as a service, it's all by contract anyway.
Quick question for Professor Chander. So I can see the Brazil's effect spreading around the world, but I could also see the resisting force against this kind of effect, especially in in the United States, where AI sector is leading the world, and compliance consider all kinds of costs that Professor Yu has mentioned. So I can see that in terms of AI development and research, countries that intend to foster AI sectors and corporations that want to develop their AI research will resist GDPR's regulation in various ways. And so how do you approach that then?
So what I think you're seeing is that some governments are hoping to develop an indigenous AI industry, and others really don't have any such hopes at all. And so the governments that are hoping to develop this want to ensure that the law permits this, is permissive in some sense. And so you saw this, if you watch the debates within Europe in the trilogue process in the last few months of 2023, as the Spanish presidency of the European Union winds down, you saw internal divisions between the member states. So it turned out that there were hopes to develop indigenous enterprise, especially in France and Germany. And the rise in particular of a French company called Mistral, which has a kind of open source AI model that's, that seems pretty powerful, led some of the folks from France to say, hey, let's not make the EU law too difficult or cumbersome, and thereby thwarting our own efforts to create essentially national champions within France. And German enterprises, including not just AI enterprises, but big corporations that have AI systems that are developing their own AI systems, to hope to offer these and develop these without a law that might be too burdensome. So I think you're going to see this question very much within the generally, and the kind of geopolitics in the United States. Also, I think the concern in the United States that China in particular will race ahead on AI if the US law is too restrictive, I think is the main reason that there hasn't been a very substantial law within the United States to tightly regulate AI. So that kind of, and you might call this a race to the bottom a problem. I mean, it has something akin to that issue. And I think this is the existing reality of the geopolitics of this change the nature of how lawmaking occurs. And so there's kind of national industrial goals and also national security concerns that are driving so much of this.
Thank you, Professor Chander. So let's open the floor for Q&A, and please be brief with your questions. So in the interest of time, I would like to collect questions first and let the two professors respond. Okay. Michael, please be brief with your question.
Very brief. A question for Christopher. You characterized data protection law as being consent-oriented, but consent is the exception in data protection law, not the rule. And you didn't mention legitimate interest, which is, you mentioned public interest, but I'm just wondering, when it comes to legitimate interest, that is the ground in European law which specifically considers the economic rights of not just the data controller, but of any other person. And so exactly the examples that you say, and it's the predominantly relied on ground. So I was a little bit confused about that. So maybe you could reframe and say why your argument would still hold, given the existence of that as the primary legal basis used in data protection law in the commercial sector.
Thanks for the wonderful keynotes. So I also have a question for Chris. You mentioned about the right to be forgotten in the data protection in artificial intelligence. But the reality is, I mean, these companies just get enormous amount of data from the web. And frankly, they don't know what's in those data. And unless these companies disclose what are the data sources and what's in the database, it's impossible for individuals to really opt out, just like the EU's proposed AI Act. Is proposing to allow copyright holders, proposing that AI firms need to disclose copyrighted materials, but these firms don't even know what are copyrighted materials. So my question is, how is it possible to, ensure this kind of personal data protection, given the reality of how, these kind of models are trained currently? Yeah.
Would the speakers identify themselves when they ask the question?
This is Angela Zhang from University of Hong Kong.
Thank you. Actually, I would like to make one clarification instead of raising question. I would like to point out that there's no right to be forgotten provision in the privacy law of Hong Kong. That is because as regulators, we are acutely aware of the impact it would have on the society in general. And that is why we made a deliberate decision not to include that particular kind of provision in the privacy law for the time being. Thank you.
Thank you. I'm Ron Yu, and I have a legal tech AI startup. Question for Professor Chander. You mentioned the at the end the desire to have regulators ask companies to share more data, but how do you reconcile that with companies' desire not to share data because of trade secrecy fears or because of PR, public relations fears?
Last question.
Hello, I'm Chinmay Arun. I'm a lecturer in law at Yale Law School. So my question is actually based on a paper that I know that Paul will be submitting in this cycle, and that is why I'm outing it, and it's to both of you. Paul's argument, as I understand it, is that fine-tuning is where the value of AI lies. And so, Professor Yu, my question to you is that do you think that that is an opportunity to solve the problem that you raised a little bit in the manner in which Tarleton Gillespie said that content moderation is where the value of social media platforms comes from? And to Professor Chander, I wonder whether this localization problem, I'm never going to forget the kangaroo example, is fine-tuning a way to deal with it? And then do you think that that will vary depending on which state AI companies are dealing with?
Unfortunately, we don't have much time left, although we need to talk a lot about many things. But so
I'll try to do this quickly. I will also never forget the kangaroo catcher. It's based on the cow catcher from Cranes. And I keep thinking about Big Bang Theory. They call it, Sheldon Cooper calls it, it shouldn't be called a cow catcher. It should be called a cow exploder. So it's an interesting phenomenon. But so very quickly. So one of the dominant things about GDPR that changed everything is it shifted consent from the preferred basis of actual legal processing to the dispreferred because of the withdrawal problems. But if you go through Article 6, this is the very legalistic thing to do, it's consent necessary for the performance of a contract. They're not contracting for AI, necessary for compliance with legal obligation, or necessary to protect the vital listeners of the data subject or another natural person, probably not going to work. Performance of a task carried out in the public interest, then that becomes a construction of the term public interest. And from what I can tell, the secondary law, for them doing it for an explicitly economic, market-based promoting thing, I haven't seen a clear indication of that. And then legitimate interests pursued by the controller or third party, except where such interests are overridden by the interests of fundamental rights or freedoms of the data subject, require protection of personal data. It's the classic balancing problem, right? Which is, we're going to end up here. I don't claim to know the secondary law as well as I'm sure Europeans do, but I'm trying to find examples where you would say, yes, there's going to be some derogation of their individual privacy rights, but the economic interests are so important. I haven't found that case yet. Okay. But so if that's the case, if there's a hook for it, even better. I mean, that's my point, is that but we need to develop this and to take it and develop it into actual metrics to actually make it implementable, because ad hoc balancing, some of the big frustrations I have with some of the secondary law in the EU is it's sort of mix and stir balancing without really, especially from a compliance perspective, it's hard to know from a predictive judgment how to think about future cases. And so I find it not as prescriptive or helpful as I would like. And so that would be a general issue. Angela, the questions about web scraping, this is a huge issue because it's not clear. There's a presumption that scraping public information is legal. Under GDPR, it's not. It's the obligation of the scraper to get affirmative basis for legal processing. And actually, there's a lurking bomb under US law under what we call the Computer Fraud and Abuse Act, because a lot of the social media companies are saying wholesale scraping is illegal. And at that point, you're violating the terms of service, and now it's exceeding authorization. The Supreme Court case in Van Buren 3-4 years ago got right to the line of saying that that's legal, but has a footnote that says, well, we're holding off on this question. And there's overhanging criminal liability. So I know that there's a case against NYU researchers who are doing, not so much commercially, but academics, they're actually concerned. and they've actually been received some notices. So there's a whole overhanging issue, but the presumption that just because it's public, it's available is not true. You actually face substantial liability from that. And about the right to be forgotten, I appreciate this. It goes to show that there are limits to the Brussels effect, that not just because Brussels adopted it, it doesn't all the way go through. What's interesting to me is this comes up in spades in healthcare, which is, for example, our Healthcare Privacy Act does not give a right to be forgotten. The data subject has the right to put a note in the record disputing a fact, but the medical doctors get to decide what's in it, because we all know the first thing you do when you do medical research is you do retrospective study on the data. And you need accurate data about incidence reports and all this to actually be able to do this for public health purposes. And so, I look at the Brussels effect, I see it in somewhat in privacy, but one of the things we're fighting about is the Digital Markets Act. As far as I can tell, there was a lot of interest in it for a while, but they don't seem, most of the countries I've seen, Korea, Japan, so they're not about to adopt it. And so it'll be interesting to see how regime specific it is. And I'm told I need to stop. So Vuchimai, I'll answer directly.
I'll be very grateful. Very quick. So I just want to touch upon Angela's question about copyright. Just want to remind you that based on international copyright law, which Europe, and really largely because of Europe, everything is essentially copyrighted. Right? So everything you write, as long as it has a modicum of creativity, is copyrighted. So training on copyrighted material is the norm. And so it means there's just the possible exposure to liability, if you take it from that perspective, might be just absolutely, will stop these companies in their tracks, except for companies that license that from the very get-go. That is, so companies like Adobe, which have been contracting with other people to provide images from the very start, building in the license to exploit their data for such purposes, right? So there'll be a very small set of companies that have that data. And so so one of the worries here about a copyright maximalist approach will be to really sharply reduce the companies that can provide these models in the future. And so the kind of copyright and competition concerns, again, are in opposition to each other we should seriously think about. Let me also turn to Ron's question about sharing. I think this is a critical question, but my quest, I think, trade secrets, et cetera, are going to be a huge problem. What we relied upon for Volvo was a kind of its own desire to be a very positive player in the industry. I think this is going to depend upon companies actually taking that proactive step on their own to a large extent. And so I think we need that kind of information sharing about the possible exploits and other harms that people have discovered, and then trying to figure out how to share them. And then the question of, can you share them with a country, with a company based in a foreign country? That also depends upon regulators being permissive and thinking about that as a positive for humanity. But I'll leave it at that.
Thank you, Professor Chander. What a phenomenal panel. I think the only reason is that we have the best keynote speakers in the world joining us today. So please do join me in thanking the two keynote speakers.